I'm the moderator today, and my name is Emily Smith. I'm the Executive Director of LERA National, and we are so happy to have with us the following distinguished panelists. First of all, Theo Cheng is here. He's an independent arbitrator and mediator located in Princeton Junction, New Jersey. We also have with us Renee Main, who's an arbitrator, mediator, and adjunct professor. She's located in Sacramento, California. She's also the Northern California LERA Treasurer. We have with us James LaRocca. He's the Director of Employment and Labor Law for Gibbons. He's an employment advocate, and he's located in Newark, New Jersey. And we have Pat Flynn, who's an attorney and counselor at law. He's a union advocate located in Houston, Texas, and also a Houston LERA officer. So I'm going to go ahead and share the questions that we have pulled out of the chat log. So hopefully you can all see this. The first couple of questions are for arbitrators Cheng and Main. Have you ever had a situation where one party wanted a video hearing and the other did not? And did you have to force the parties to do a video arbitration hearing? If not, could you maybe discuss what that would look like hypothetically? And if this came in separately, I don't know, I'm not an attorney, so if a Section 301 case is different, please expound upon that as well.
Renee, would you like to start?
Sure, thank you, Theo. I've had numerous times where parties could not agree, particularly earlier in the pandemic when just the idea of a virtual hearing was so foreign. And in those cases, the individuals rescheduled going forward multiple times and eventually mutually decided whether to hold a virtual hearing or hold it in person. The in-person cases that I've had during the pandemic have been law enforcement cases, and they've been consistent in mutually refusing to agree or mutually agreed not to hold a virtual hearing. With the exception of one case recently where just 2 work days before the hearing, one of the parties decided that wanted to hold a virtual hearing. And after hearing the arguments from each, I encouraged them to reach an agreement. And when they couldn't, I encouraged the party who wanted to have the virtual hearing and the other party wanted to have in person, ask him how he could find a way to accommodate both what he wanted as well as the other party. Eventually, they both agreed to hold it in person as planned.
My experience is very similar to Renee's. Early on in the pandemic, parties were very reluctant to simply switch to a remote hearing format. And a lot of them wanted to postpone the decision-making for some time. And I let them because they were in agreement to do so. But ultimately, when there is a disagreement, early on, in fact, I had a case in which I asked the parties just for briefing on the issue. Because you do need to balance as an arbitrator the notion that you want to protect people's safety and health, while at the same time, delivering on the promise that arbitration is supposed to be a cost-effective and expeditious process. But at the same time, this is the parties' agreement, and there are expectations and anticipations about having a hearing appear in person, and there are definitely pros and cons. So I think the better practice is always to get as much input as possible from the parties if you're an arbitrator placed in a position where you need to make a ruling. The other thing that I will say is also it doesn't have to be an all or nothing proposition. There are many ways to cut up a hearing where, for example, some of the participants could be together in one place, but others may be remotely zooming in, which is usually the case when you have one lone witness who's not at the location of the evidentiary hearing. So for example, I have a situation in which the attorneys and the arbitration panel want to be in one place with masks and social distancing, But because the witnesses are all coming from all over the place and they're not going to be spending significant time with the other participants, we're going to have a separate room set up where the witness will appear and be cameraed or zoomed in to the other room where the arbitration panel and the advocates are. I also have a case right now where they'll be sending briefing to me in a couple of weeks regarding the issue of remote depositions. So the same considerations are present there. But again, it's the better practice, again, is just to get everyone's viewpoints and have a robust record. As you may know, I actually wrote an article on this during the time of the pandemic because it kept coming up so much. So nowadays, I just send out the article to the participants and say, please read this first. And then provide me your views, and then I'll issue, some sort of ruling.
Thank you. And the Section 301, is that a different case that needs to be addressed, or can we move on?
That may be a Texas statute.
Okay.
I could weigh in a little bit there. So a Section 301 case is a case alleging a breach of contract under the Labor Management Relations Act, and that contract, of course, is the collective bargaining agreement. Does anyone know of a Section 301 case to compel arbitration based on one party not agreeing? I'm not aware of a case in that context. Pat, I don't know if you are.
Well, no, I haven't heard of one, but I thought about that during this program. I was going to run that by you to see what you thought, because I think, and I know some of the federal judges here in Houston, if you and I, for example, had a dispute over whether we were going to agree to go to a virtual hearing, and the arbitrator decided, look, I'm not going to make a decision. I'm not going to force either party. I think that if one of us was, bent on forcing a virtual hearing, we could file a suit to compel arbitration. And I think at least some of the federal judges here in Houston would be sympathetic to order a virtual hearing. I think that's, another option.
Okay,
I'll just add quickly that, in this regard, for a Section 301 case, which is outside my wheelhouse, but I would say that the National Academy of Arbitrators has issued an advisory opinion number 26, which I find very, very helpful, because it discusses these issues within the context of a collective bargaining agreement and the sort of norms and expectations that James was alluding to that parties go under in that kind of context. So that's worth looking at to get some guidance.
Thank you for mentioning that, Theo. You can actually find the arbitration resolution number 26 linked on the website event for today's event, if you're interested in reading that. And also another article that Theo Cheng wrote that is kind of a companion to that. All right, next question. So for advocates Flynn and LaRocca, have you ever had a situation where you were forced to participate in a video arbitration over your objection, or where the other party was forced to participate in a video arbitration over their objection, and how did they respond, and how did you feel about it?
Well, I can say no, I haven't. But I think, as most people have experienced, and I think James and I kind of touched on this at one of the prior programs, earlier in the pandemic, I would say everybody that I dealt with, felt the same, like, well, let's just hold off for another month or two. And I did have an arbitration case, a termination case that was pending in that realm. And I was getting a lot of pressure from the grievant. And so in turn, I kind of pressured the company counsel to agree that, we did reset this case, I believe, 3 times. And I told him that, if we weren't going to do this in person on the 3rd setting, a week or so before that date, we're going to agree to do this virtually. And he eventually said, okay. So that's kind of how that went. But I've never been in a position yet where I've been forced, one way or the other.
And
Thanks.
I haven't been in a situation where we were forced either. And my experience is the same. At first, we were a lot more reluctant than we are now to proceed with these video arbitrations. And I think a lot of that was just not trusting the process or it being uncomfortable. And then we got to the point where you really had no choice because this is just ongoing with no end in sight. And you do one or two and you get used to it and it's working and everyone seems a little bit or a lot more comfortable with it now than we originally were.
Thank you for your comments. Here's another question that seemed very lawyer-like that I didn't truly understand, but I will relay it to you. Can one party preempt the arbitration clause? And forgive me if it's already been answered.
I think we just addressed that, didn't we, James?
Okay,
I think so.
that's what I was fearful of because I don't really know all of the legalese. All right, so we'll proceed on to questions that we can open for all panelists that are here. And this one came in specifically for Ms. Connaughton, but she's not here with us. So have Ms. Connaughton or other labor side counsel changed their position about resisting remote hearings now that they're several months into the pandemic situation? And this individual stated that as a labor side attorney, they have urged remote hearings, especially for disciplinary matters.
I would have to agree with that.
Okay. And what is the biggest ethical concern or concerns that you have concerning video arbitrations and or mediations? And do you have any suggestions on what can be done to ameliorate those concerns?
I will answer that. I will just say that I really don't have any significant ethical concerns until something would arise. The reality is that in an in-person hearing, even if the parties agree they're not going to record the hearing, someone may secretly do that. Even though individuals are advised not to speak with anyone about their testimony, in the case that they get recalled, they, with the exception of their counsel, they might. Sometimes it happens and I wouldn't know it. So the issues that could arise in a virtual setting, from my experience, are not any different than ones that can arise in person. And so we rely on people's honesty and integrity to ensure that there is a fair evidentiary hearing.
Understood.
I would agree with what Renee said, and I'll just add something else. I'm not sure this is really an ethical concern, but I do harbor some reservations in the current environment, meaning right now in the October-November timeframe, where we know so little yet about the coronavirus and what steps could be taken to be really safe and healthy. If I'm the arbitrator that ultimately orders parties to appear for an in-person hearing sometime in the near future, and as a result of participating in that hearing, one or more of the participants get sick, that sort of weighs on me a little bit. You know, obviously things change and regulations and scientific data change over time. So that's why I really ask the parties to brief me as fully as possible on all these issues before making that determination.
It's a great comment.
I would like to just add something to this concern section. I mean, we've kind of, beat to death the ideas of who's recording and not recording and how all that works and what happens in the caucus rooms. And but here's a little concern that I have just from personal experience, and that is the witnesses' ability to use the technology. For example, if we were doing one of these private telephonic caucuses that we've all talked about, you would expect the parties to turn the microphone off and turn the video off. And just from personal experience, I've seen where they're not really sure about how to do that. So that's just another thing I think for us advocates to have to train our clients and the witnesses so that we don't, get into some kind of a ethical jam. James, what do you think?
I think that's a very well put point. The worst situation is, your other side is going to hear, at least half of a privileged conversation, and that's putting everyone in a bad position, including the attorney that overheard it accidentally. So, yeah, it's a very good point to be cognizant of making sure everybody knows how to work the technology, including off the mic.
So do any of our panelists today have any security concerns with using video ADR? And if so, what are they? And why are they concerning? And how can you overcome those issues?
I don't have any security concerns. I use protocols in the platform, or if the parties are hosting or they hire an administrator, I just work with them to make sure that that the process is confidential.
There were a lot of security concerns in the beginning of the pandemic, but largely they've been addressed by the platform providers. And a lot of them were really user error related. And as more people become educated about how to use these platforms properly, and as Renee said, if you have robust video teleconferencing protocols in place, if you rely on the honesty and integrity of the participants, as she noted, you shouldn't really have those kinds of concerns.
I would just say one other thing. I've already brought up my concern about the people involved being able to operate the equipment from just a witness and client standpoint. But I would insist that whether it be an arbitration or a mediation, that the arbitrator or the mediator run the program, host the platform, if you will. And if either one of those individuals is not willing to do that, then we get a service, like a court reporting service, to be the host. That would be my, I guess, supplemental security concern, if you will.
Thank you. So now that all 5 video sessions of the virtual ADR from A to Z have been shown, what are your feelings on the future of virtual ADR after the pandemic? Anyone?
I'll just jump in and say that I think that the world of work has changed during the pandemic, and that while we have used virtual platforms before the pandemic, and in fact for many, many years, the reality is that this became vital, especially for people who are at risk. And I think that it will be a tool in the ADR field going forward. Once the pandemic lifts, there will still be reasons that people would like to use a virtual platform, and it works. We've proven that it can. So have many courts throughout the nation. It is a viable option in lieu of either being able to meet in person or choosing this platform.
We have sort of a concurrence of opinion on that. If it was totally your choice, would you choose an in-person or a video ADR? And if so, why?
Well, my thought on this is that the default is going to be in person once that's clearly available. But I also agree that this technology is not going to go away and will be a useful and important tool to use, especially with a remote witness. I mean, it's not at all unusual to have an in-person arbitration and you've got one witness who just can't make it for one reason or another. Maybe they're even, overseas. This platform will certainly fill that in a very, very good way. I also think there may be some cases where they're very short, for example, where you just don't have a lot of testimony, maybe one witness on each side, one document on each side, and it could be done in 1 or 2 hours. I can see the party saying, well, let's just do this by Zoom.
One question that was posed to me in the video was the idea of having a larger reach geographically, because there's, don't need to travel. From a cost standpoint, I think that also makes sense, and people will be more receptive to, the virtual ADR for that reason alone. If we could do it and it makes sense to do it, and we could save everybody some money, client costs, that's another good reason for doing it. Being in person at times is irreplaceable, I think, especially with what we do as labor law practitioners. I'm thinking largely, collective bargaining. While that also could be done effectively remotely, I think having it in person, periodically is also important to that. So I'm not fully on that yet either.
Does anyone have anything else to add from our panelists? If not, I will turn it over to Walter Dar.
Hey, thanks, Emily. And I'd like to thank all of our panelists and our attendees. I hope everybody's benefited from the presentation and the robust panelist Q&As that stemmed from those presentations and from our participants who submitted questions. I know I certainly have. Throughout this 5-part series, I've been very humbly reminded why our fields are so very often referred to as the practice of arbitration or the practice of mediation. Certainly always something to be learned along the way from our peers. I'd be remiss if I didn't take a couple of minutes just to recognize a couple of organizations and a few folks whose hard work really drove our organization, Houston LERA chapter, to being able to put this series on. First, I want to recognize LERA National and the New Jersey chapter, without whose hard work and partnership we couldn't have offered the series. Second, Emily Smith, National Executive Director of LERA, and Bernadette Tiemann, LERA National Membership Marketing Coordinator, without whose leadership and participation we couldn't have offered the series. Hats off, and thank you, Emily, and thank you, Bernadette. Third, I want to recognize our own Houston chapter treasurer, Mickey Brock. Mickey really took the reins and spearheaded the efforts of making this series available to the Houston LERA organization and for all of you. Thanks, Mickey, for all your hard work and commitment to the Houston LERA family. We appreciate it. Last and certainly not least, I want to recognize Moretta Tate, who's a member of our Houston LERA chapter board of directors, and without whose help the Texas Attorney CLE credits certainly could not have been granted. So, Moretta, thank you very much. You've done so much for the Houston LERA chapter, and this is just one more thing that you've stepped up and done. So this will end today's session. Thanks everybody for attending. We hope to have you join or extend your Houston LERA and LERA National memberships. You can do so by visiting lerachapter.org/Houston. And we hope to see you at future Houston LERA events. Take care and be safe. And until then, thank you.
Thanks, everybody.